One nation, under God, indivisible, with liberty and justice for all. If you're an American, you probably know these words, the final line of the Pledge of Allegiance. But what's with this phrase, under God? Sounds kind of religious for a country that supposedly supports the separation of church and state, right? However, the Supreme Court has actually defined this as a secular statement. On Flag Day, June 14, 2004, the Supreme Court ruled against a parent who objected to their child saying the words "under God" in the pledge. The parent, Michael Newdow, argued that the phrase endorses a religion and therefore violates the First Amendment of the U.S. Constitution, which says, "Congress shall make no laws respecting an establishment of religion or prohibiting the free exercise thereof." However, the Supreme Court disagreed. Justice Rehnquist, writing in agreement with the majority, said that the words were merely patriotic. The phrase "under God" is in no sense a prayer. It is a patriotic exercise, not a religious one. Justice Sandra Day O'Connor wrote that it is an example of ceremonial deism, a statement that started out as religious, but slowly and surely lost its religious character by constant repetition over the course of history. So, apparently the Supreme Court has taken upon itself the duty to define religion. But how do they distinguish between the religious and the secular? Why do they say one thing is merely patriotism and not religion? Let's look into it in episode 4 of American Civil Religion.
What shouldn't be happening is government taking a view on religion and saying that there exists a God.
One thing I think became very clear today by the Supreme Court, and I think probably unanimously, and that is the Pledge of Allegiance is a reflection of the religious heritage of America and does not constitute a violation of the Establishment Clause.
Now, when the Supreme Court defines what counts as religion, endorsement or advocacy is usually the key issue. Take, for example, a 1984 case about Christian Christmas decorations on public property. The court framed the issue as a question of whether public display equals advocacy. Does displaying a nativity scene on town property mean that the town government is advocating for Christians? Does that establish Christianity or promote it? The court said no. They didn't deny that the display was religious. They agreed it was. But the majority argued that it was historical. The display of a nativity scene could be justified with secular intents by seeing it as educating the public about the history of the holiday. The court claimed it was like the exhibition of religious paintings in governmentally supported museums. Now, one of the challenges to this line of argument is that it leaves many issues unexplained and dismisses the power of religious symbols. A religious painting isn't religious when it hangs in a government museum. Okay, but what makes it not religious? Simply displaying a religious thing in a non-religious place doesn't necessarily erase its religious qualities. How can we know when someone does or does not experience a symbol in a religious way? But it doesn't really matter because the court sidesteps these issues, because the legal question is about establishment and not free exercise. The 1984 Christmas decoration case is the first time a Supreme Court justice used the term ceremonial deism. Even though he thought a Christmas display is unconstitutional, Justice Brennan agreed that certain religious expressions could lose any significant religious content through rote repetition. But how do we decide if something is ceremonial deism? Well, 20 years later, Justice O'Connor's agreement in that 2004 Pledge of Allegiance case built on this idea by creating 4 criteria whether something is ceremonial deism rather than religious. Ceremonial deism is historical, widespread, not worship or prayer, not tied to any one religion, and minimally religious. Now, I see a lot of problems with this framing of ceremonial deism. Repetition is fundamental to the persistence and growth of religion. Prayer, worship services, hymns, even the repetition of symbolic gestures like crossing oneself or bowing. Religious persons see the cultivation of such habits as good and desirable, and they're definitely not minimal. They're essential to the religious lives of billions of religious people. So the court has presented 2 options. See something like a nativity scene as a religious thing that is more historical than religious, like a painting in a museum. Or see it as a thing that used to be religious, a thing slowly secularized by constant repetition. Both perspectives ignore the power of religious symbols in order to make their claims, and both say that the court's secular readings of symbols supersedes a religious reading of symbols. The Supreme Court continues to shape religious freedom law to this day, like when they upheld the display of this giant World War I memorial in the shape of a Christian cross located in Bladensburg, Maryland. The American Humanist Association filed a lawsuit against the memorial, arguing that it violated the Constitution's Establishment Clause. But in 2019, the Supreme Court decided that even though the monument was admittedly Christian, it had historical importance beyond its religious symbolism. Yes, it was a Christian cross. No, it's not establishing a religion because it's a historical war monument. In other words, the court gets to decide when something is religious and when it's not. Whether we're talking about a symbol like a cross, a phrase like "under God," or a decoration like a nativity scene. You might say that the Supreme Court's constantly evolving job is to articulate what counts as religious and what does not. Like religious studies scholars, the court is extremely reluctant to attach itself to a single, simple definition of religion. The danger of a weak definition, one that's too rigid, too broad, too dependent on internal beliefs, would be powerless to treat each case on its own merits. The justices have been very open about the ways in which the court struggles with a one-size-fits-all approach to establishment cases. Monuments like the Bladensburg Cross were erected by specific groups to honor fallen soldiers. The court must ask about intent, but then must consider how the experience of the monument has changed over time to judge whether it has a reasonable secular purpose today. If they can justify it without religion, it gets to stay. In other words, a cross has a religious intent, but the purpose of the monument is secular. Ironically, this is not the case with the phrase "under God" in the pledge. The intent and the purpose were obviously religious from the start. Like the motto "In God We Trust," "under God" has a surprisingly modern history. President Dwight Eisenhower signed the law adding the words "under God" to the pledge on Flag Day, June 14, 1954. He did this following a campaign led by the Catholic group the Knights of Columbus. The goal was pretty obviously religious in nature. Michigan Senator Homer Ferguson, who sponsored the bill, said its goal was for each school child to reassert their belief in the all-present, all-knowing, all-seeing, all-powerful Creator. The bill passed unanimously in both chambers. 50 years later, on Flag Day, June 14, 2004, the Supreme Court made the ruling against Michael Newdow, who didn't like their kids saying "under God." But even though the court said it's just secular patriotism, other people did not agree. The President George W. Bush at the time framed it in religious terms. As the case made its way through the courts, he used it to explain the kind of judges he'd nominate. Common sense ones who understand our rights were derived from God. So it's important to remember that the Supreme Court, and all courts and lawmakers in the United States, have a tremendous amount of influence shaping these discussions. Lawmakers made "under God" part of the pledge explicitly to show that Americans were not godless communists. As time went by, the court came to argue that the intent of the addition didn't matter because it was historical. Then it argued it wasn't really religious. Then it argued even if it was religious, it was only minimally religious. This is the process of categorization and definition. Defining religion is not just academic theory crafting. It has real-world effects. The court is the place where beliefs and practices get translated into decisions, identifying what is permissible by law. They balance a host of competing legal principles, but in the end, the court nearly always has to decide whether and how a religious thing is religious in order to make its decision about whether it's legal. In other words, in order to say what's legal, the court must always say what counts as religious. As always, thanks for watching, and I'll see you next time. Hey everyone, so this was episode 4 of a 5-part series on American civil religion. You can watch the other episodes somewhere here on the screen. Special thanks to our patrons on Patreon for making this series possible.